interestingly, not only a forest officer, but I think just before his retirement, sir has completed his LLB in 2021. And I think, sir, it was a retirement plan, because after that, I could see that you were busy with the Supreme Court, Bombay High Court, National Human Rights Commission, etc., appearing on behalf of biodiversity conservation, human rights, and even some farmer suicide cases. So, with your wide range of expertise and your understanding of the law and the law enforcement and rights of people, you will be able to enlighten us in multiple ways. Thank you, sir, joining with us. And before I invite you to start the conversation, I would like to invite Advocate Lovish also. Lovish Sharma is a practicing lawyer in the High Court of Delhi, and he is a consultant lawyer with the Wildlife Trust of India for last few years. He is a trainer with the Wildlife Crime Control Bureau, various state forest department, and all a good friend who is very much active across the country whenever there is a emergency legal opinion needed. He is the lawyer we could call in the middle of the night and ask for legal opinion. Lovish was instrumental in providing legal opinion inputs, advices in many policy matters and trial court cases, and also currently partnering with us in some of the key legal projects across the country. Welcome, Lovish, also to this session. I would like Lovish to introduce the subject and the context in detail to the participants. Thank you, everyone. Welcome, everyone. And over to you, Lovish. Lovish, over to you.
Yeah, Jose. Actually, all the participants were muted, so I was not able to take it from you. Good evening to all the participants. It's a pleasure to be part of this webinar. It's a very interesting subject to talk about, and it's a great pleasure that Mr. Srivastava is here with us, talking on some very important issue wherein these two laws we see on daily basis, confronting each other. So what is this Rights Act 2006 vis-a-vis Wildlife Protection Act 1972? So just to, because as Mr. Srivastava is a key speaker, so I won't take much time today because I think he's better and well-versed when it comes to the FRA 2006, given his vast experience in the forest bureaucracy. So this act, just to give a brief background, it was enacted back in 2006. And very important legislation because you see from colonial time, we see that there was this shift where the forest, which was taken as a resource base for the sustenance of the scheduled tribes dwelling in the forest and other traditional forest dwellers. So we see that the focus shifted from forest being a resource base for such tribes to be a state resource for carrying on commercial activities. So gross injustice happened with such scheduled tribes dwelling in the forest areas where they were using and they were dependent upon the forest for their bona fide livelihood. And then overnight, these people were actually termed as encroachers during the colonial era. We see with the enactment of the Forest Act 1865, the first act which was enacted by the Britishers that time. And till 2006, we see that these dwellers have actually suffered gross injustice by the state authorities because their centuries-old rights were curtailed in terms of, when this hogwash was created, that for the conservation reason and for other commercial activities, the people who've been living and actually conserving our forests in India were termed as encroachers. So now this act provides for various rights. Broadly, there are 4 rights in the act which have been vested with the forest scheduled tribes and other traditional forest dwellers. These are the title rights vested with them. And then we have the usage rights that they can use the forest produce in a restrictive manner for their sustenance. Then there are other rights, whether it's the conservation management, they can have their own community reserves and they can manage it. They've been vested with such rights. And then there is this process involved where people can actually claim forest rights under this act. So we have Gram Sabha, the village sabhas, which would certain such people's right if they claim to be a forest dweller. Is so. So now with the enactment of this act, and the question comes whether, and this is the topic today because the deliberations are upon whether both these acts, the Wildlife Protection Act 1972 and the Forest Rights Act, whether there are provisions in the written law which is in conflict, or whether it's the enforceability of both the laws which causes conflict between the two laws. So that is to be seen, because whether it's the bureaucracy, the government agencies which are not sensitized about the Forest Rights Act, and very often this law has been termed as a hindrance for furthering the cause of wildlife protection in India under the 1972 Act. So this is our today's discussion, and with this I'll hand over the session to Mr. Srivastava, and I warmly welcome Mr. Srivastava. He's a learned forest bureaucrat, and I've been in touch with him from a very long time, and it's always a pleasure talking to him and knowing his side of how the forest works and how the laws can be interpreted and can be enforced. So I welcome you, Mr. Srivastava, and I hand it over to you from now, sir. Thank you.
Good afternoon, good evening to all dear friends, and good morning to those who might have joined from US or Canada. Well, at the outset, let me thank WTI, Mr. Jose, Mr. Lovish, for giving me this opportunity to share my views on a subject which is often misconstrued, if I may use the word. This is the first webinar I have joined after retirement from the service way back in March 23. Therefore, my comments would be more from the point of view of a dispassionate observer with no leaning either on the side of forest bureaucracy or on the side of FRA proponents. With this brief background, may I request host to kindly start the presentation, please. Just the first slide, please. Before he starts, just 2 points to flag. Wildlife Protection Act was enacted in 1972. Forest Rights Act came into 2006. When I joined the service in 86, for 20 years, I served in an environment when FRA was not there. And post 2006, also I have seen the era of FRA. Just one little correction about the general perception that prior to 2006, there was no system to address the concerns about the tribals is a little misconceived, because if we read Indian Forest Act, there are provisions to accommodate concessions and privileges of forest dwellers. It, in some states, is also known as Nistar rights. So these concessions were there, and these tribals and dwellers were enjoying, except for the right to title. Title was not there. I had the privilege to work in Gadchiroli district for about 4 years and also in Melghat for about 6 years. So during the period, I have seen wherever the concessions and privileges of these forest dwellers, whether they be in the terms of collecting minor timber, fodder, or minor forest produce, were addressed appropriately, discomfort was much less. But wherever they were not, problems were there. In a way, Forest Rights Act 2006 elevated the status of concessions and privileges to the level of right. I am aware of the incidents where these concessions and privileges were not appropriately awarded. They were not really incorporated into the records, with the result, certainly there were incidents of injustice through which these tribals and forest dwellers had to undergo. And those were perhaps the reasons which triggered the enactment of Forest Rights Act. With this little background, may I request to move on to the first slide, please? Next. Yeah, just prior to this, just to give all the viewers a snapshot about the extent of the problem so far as its geographical dimension is concerned. If you see the central India, majorly the central India and northeast India, here scheduled areas overlap with the forest areas and also tiger reserves, national parks and wildlife sanctuaries. FRA primarily is applicable to scheduled areas as declared in Schedule 5 and 6 of the Constitution. So today I am confining my discussion precisely to the interaction of wildlife management and the welfare of scheduled tribes and forest dwellers in the scheduled areas. If we have a look, we find that especially the states of Gujarat, Maharashtra, MP, Chhattisgarh, Andhra Pradesh, Telangana, Karnataka, and most of northeastern states have problems, have issues in regard to the interest of tribals and the wildlife. This issue becomes more critical and crucial in backdrop of the development thrust which our present government has given. The idea of sustainable development, how we harmonize the interests of tribals and the wildlife management, becomes the core issue for us to really deliberate upon. Next slide, please. This is a brief slide which will give you an insight into the extent or rather nature of forest dweller rights. The very first question which must be coming into your minds that when we say forest dweller, what forest dweller means? As per the Act, that is FRA 2006, Section 3, it states that members and communities of scheduled tribes and also those who did not belong to scheduled tribes but had been staying there in the forest areas for nearly last 3 generations, approximately for last over 75 years in the forest, primarily for their life and their bona fide livelihood requirements, they have the right. Now, what is the nature of right? They have right to hold and live in the forest land under single or common occupation for habitation of self-cultivation. Just to give you an example, in Gadchiroli, there is a taluka which is known as Bhamragad. I worked there from the period from 2000 to 2004. Even when these rights were not there, approximately 70% of the forest areas, actually these forest dwellers and tribals were living there, staying there, and they were meeting their bona fide requirements. Problem only was their occupation of the land was unlawful. Because the nature of occupation was unlawful, certainly they had to face problems whenever some official who had some vested interest came into their areas. Otherwise, there was no problem. Then, secondly, there were these rights include community rights. Nistar means, for example, in Maharashtra, there are rights about bamboo. Certain number of bamboos have to be given, rather can be given to a forest tribal family for their bona fide use for the construction of their houses or for making some handcraft goods out of bamboo. Then right to collect, use and dispose of minor forest produce. Minor forest produce include tendu leaves, bidi leaves. Lot of medicinal plants are there which have got huge value. And these rights actually had been traditionally part and parcel of their life. Then right of uses and entitlements such as fishing, grazing, or traditional resources of nomadic tribes. Wherever water bodies were there inside the forest, these tribals had got traditional right to go there and fishing. Grazing also was part of their rights. Earlier also it was there, but then it was in the nature of concession and privileges. The act provided these concessions in form of rights. Therefore, status of concessions and privileges were raised to the level of rights just to safeguard their legitimate interests. Right for conversion of patta. When we use the word patta, during 96, around 1976, there were a lot of areas also in Maharashtra where these tribals, whatever land they had been tilling for a number of years, those lands were actually provided to them, titles were given to them in form of patta. Legality of this patta was questioned by courts, and there were a number of litigations. And this FRA provided end to all these litigations because this FRA provided legal entitlement to these tribals. The fact remains these tribals had already been tilling these land for all these years. Right of settlements. Right of settlement includes that if some compensation is to be awarded to these tribals would be legitimate, would be legally entitled to that. Next slide, please. Now, here you may see a photograph. This is they are tribals of Koraput in Odisha. There are tribal families there in Melghat also. When we say that they had been given right to protect, conserve, regenerate forests, wildlife, and biodiversity, the fact remains, for all these years, when this Wildlife Protection Act was not there, FRA was not there, Indian Forest Act was not there, these people had been protecting and conserving the forest and wildlife for all these years. Right of access to biodiversity, privilege, what they already had, was given the form of right. Similarly, traditional rights. However, this act has taken care that traditional rights, which included hunting, trapping, or hunting wildlife, was excluded. Therefore, the concern about wildlife management has been very prudently taken care of while granting rights to these forest tribals. Right to in situ rehabilitation was the provision where wherever these tribal families wanted to get rehabilitated in situ, wherever they were, those tribals were rehabilitated. Special provisions were provided for schools, dispensary, drinking water, irrigation channel, roads, community centers under Forest Conservation Act 1980. Precisely, these facilities were extended to them to facilitate a better environment to them to contain their discontent, which was genuine. When the whole world when the whole country was moving along the path of development, these tribals could not have been deprived just because there was a Forest Conservation Act. Therefore, the special concession was made. At the same time, safeguarding the interest of forest conservation. This permission was to be given only if less than 1 hectare forest land was involved and felling of trees was less than 50 trees. In nutshell, if we see the rights which actually have been provided under Forest Rights Act, we can very safely infer that interests of conservation, whether of forest, wildlife, or biodiversity, have been safeguarded in a very systematic manner while accommodating their bona fide rights. Next slide, please. Now, as John D. Rockefeller has very appropriately put, every right implies a responsibility, every opportunity an obligation, and every possession a duty. No right is complete unless or until those people who are enjoying the rights also are sensitized about their duties. Therefore, a special section is in FRA 2006, which entrust upon these tribals a duty to protect wildlife, forest, and biodiversity. Protection of catchment area, water resources also was part of their duty. And these tribals or forest dwellers were practically sensitized not to engage in destructive practices. As many of you may be knowing, there's a practice of jhum in northeast which is destructive to the forest. So such practices which were destructive to the forest conservation of wildlife, those were not permitted, and they were supposed to have observed this precaution. Then Gram Sabha was given the right to regulate access to the community forest resource and stop any activity if that adversely affected wildlife, forest, or biodiversity. In a way, if we see the Act, FRA 2006, we find a judicious blend of right and duties. If rights were awarded, duties were impinged upon these forest dwellers to ensure that resources they are enjoying are there available to them till perpetuity. That is the essential core principle of sustainable development. Next slide, please. Now, in this backdrop, if we see the provisions which are given there in Wildlife Protection Act 1972, core of the Wildlife Protection Act envisages protection, conservation, and management of wildlife. Protection of the wildlife is extended practically everywhere, whether it is in national park, wildlife sanctuary, conservation reserve, or outside. However, task of conservation and management also have been entrusted upon the wildlife wing so far as the national parks, wildlife sanctuaries, and conservation reserves are concerned. The most important provision, I think, in Wildlife Act, which harmonizes the provisions of FRA, is Section 38, Roman 5, 4, Roman 2, which reads as, subject to the provisions contained in the Act, while preparing tiger conservation plan, ensure the agricultural, livelihood, developmental, and other interests of the people living in tiger-bearing forest or reserves. Those issues have to be addressed, and management plan, which has been prepared for a tiger reserve area, it should aim at coexistence between wildlife and human activity and due recognition to livelihood, developmental, social, cultural rights of the people, wherein the limits of such areas are determined on the basis of scientific and objective criteria in consultation with Gram Sabha and expert committee for purpose. Essence of the provision is that while preparing management plans, whether for tiger reserves, wildlife sanctuaries, or conservation reserves, social, cultural, and traditional rights of local peoples have to be understood scientifically in qualitative and quantitative terms with objective criteria so that without compromising their rights, conservation of wildlife is taken care of. Special provision is there that this has to be done in consultation with the Gram Sabha. Consultation with Gram Sabha becomes very important because traditional rights, traditional practices are best known to Gram Sabha and the local people, and wisdom of any forest officer or wildlife manager lies in understanding them, understand concerns, convincing them if any particular right has to be reduced or marginalized. The basic essence of this particular provision lies in developing mutual trust between forest dwellers and the wildlife managers. Legal provision exists, and also there's mention of expert committee. This expert committee is supposed to understand the finer nuances of wildlife management so that the rights privileges of local people and wildlife management principles are fine-tuned, harmonized. They need not be compromised. Harmonizing is the objective, not the compromise. Next slide, please. Next slide, please. Yeah. Now, with in backdrop of Forest Rights Act and Wildlife Protection Act 1972 provisions, let us have a snapshot of the issues which emerged at number of places in the country. Well, one issue is specifically, I mentioned the order of National Tiger Conservation Authority, which dates to 28 March 2017, where they mentioned that because the lines of the ecological critical habit were not really decided, therefore, till then, these forest right claims, their settlement should be put on hold. With the result, a lot of forest rights remain pending in tiger reserves like Melghat, Dudhwa, Jaldapara, Yaval. This situation is of 2070. By 2023, this settlement might have taken place. I do not have any specific figures about these tiger reserves, but just to give you an idea about the total claims and how many of them were settled and how many of them are pending. Yesterday, I was seeing Ministry of Tribal Affairs site. It mentioned that out of total claim, 51 claims were settled, 40% rejected, and 10% continue to be pending at national level. Even though these problems were there in these specific tiger reserves, silver line lies in the fact that there is BRT Tiger Reserve, where the support of NGOs like ATRE, ATRI, BGKKK, SAS extended the help and community forest rights of 16 PODUs. Those settlements are known as PODUs there of BR Hills were recognized. And to that extent, I would say in BRDTR, a harmonious understanding between the two provisions of the Act was witnessed. Similarly, PAL, Tiger Reserve also is a case where 10 community forest rights were accepted and their implementation is in progress. Now, again, this data I have taken from my Google search. By now, a lot of progress might have taken place in these two places, but these two incidents, BRT, Tiger Reserve, and Simlipar Tiger Reserve, certainly are examples from which we can learn that harmonious existence of the two is possible. Two links I have given here underneath this. Those who want to have a deeper understanding about these issues may go through these particular sites and they may get more insight into the issues why settlements in some tiger reserves could take place while at other places could not. Next slide, please. Now, let us come down to core issues now. So far as acts are concerned, provision of forest right, section 3, Roman 1, and section 5. Sorry, there's a provision for coexistence between Forest Rights and Wildlife Conservation Act. Section 3, Section 3.1 and Section 5 of Forest Rights Act, if they are read with Section 8, Roman 5.4.2 of Wildlife Protection Act, we will find that legally there is no problem. They have been intended to coexist. Now, problem is, rather I would say challenge is there, how to translate this legal mandate into ground reality. As we have seen from the examples, where sensitive NGOs have stepped in, where officials seem empathetic, who were cognizant of both the dimensions of the problem, social as well as ecological. Their implementation moved on, though at a snail's pace, but they did achieve some success. Cutting the long story short, legal provisions exist. They intend for coexistence. It is up to us to find a solution for translating this legally mandated objectives to ground reality. Next slide, please. Yeah. Now, so far as the overlap between Forest Rights and Wildlife Protection Act is there, this overlap is inevitable. As we have seen from the very first slide, wherever scheduled areas are there, tribals are there. Wherever tribals are there, scheduled areas are there, tiger reserves are there, wildlife is there, tribals are there, and sustainable, as it is mentioned in the preamble of Forest Rights Act itself, sustainable use, conservation of biodiversity, maintenance of ecological balance is strengthening conservation regime while ensuring livelihood and food security to forest dwellers and scheduled tribes of scheduled areas. That is the objective. Now, Gram Sabha is interested legally to prepare management plan which is in sync with the principles of tribal welfare, forest, wildlife, and biodiversity conservation management principles. Secret lies to prepare these management plans to provide technical support to Gram Sabhas who may be aware about their rights, but they may not be having the technical knowledge to really translate those rights into document. So provisions are there, and duty upon forest officer or wildlife manager, or for that matter NGOs, is there to ensure to educate and sensitize these Gram Sabhas so that a clear-cut roadmap for better implementation of the two provisions, which apparently are seen to be in conflict, is achieved. Naturally, wildlife and forest rights intersect. Issue is how to harness. Next slide, please. Now, this is a mention of certain cases which I could see from Google. Constitutionality of Forest Rights Act was questioned in one of the petitions where Wildlife First versus Union of India was the case, which the matter was discussed at length before Honorable Supreme Court. And Honorable Supreme Court upheld the constitutionality of FRA, primarily after examining all provisions and finding that no provision really jeopardizes the interest of wildlife or forest anyway. Again, if we see, there's a case, Center for Environmental Law, World Wildlife Fund versus Union of India. This is writ petition civil 337 of 1995, popularly known as WWF. General nature of mandamus, if we see, of Supreme Court, it states that provision of FRA in regard to livelihood security must be complied with. Nevertheless, unlawful occupations need to be ejected at the same time. Notion that FRA provisions run counter to the directives by Honorable Supreme Court in Thiru Godavarman case prima facie appear to be misconceived, and I think they have been reiterated by number of high courts and Honorable Supreme Court about I was just going through these litigation there. Till about 2015, to 2016, there were about 80 litigations all over India, including Supreme Court and High Courts of Gujarat, Uttarakhand, Kerala, Bombay, and so many others. I've provided a link if somebody is more interested in knowing about the judgments. They can go through this link and find more information about this. Next slide, please. Now, here comes the slide which, in my personal view, should provide path for harmonizing the apparently looking conflicting principles of forest rights and wildlife management. Pragmatic conservation plan and forest right management plans are the answers. Every tiger reserve has got its own unique problems, economic and social, economic, and political. Now, it is the wisdom, it is the innovative solution which has to come from the local forest officers. And I have seen wherever these forest officers were innovative, they ingeniously provided solution to both these problems. So pragmatic tiger conservation plan and forest rights management plan can provide the answer. These forest areas also have got a lot of NTFP and NTFP based market support to strengthen livelihood security, adequately supported by Eco Development Committees, Joint Forest Management Committee, and Biodiversity Management Committee within sustainable management principles can provide the answer. One novel solution can come from CSR, under the auspices of CSR or CER, where corporates may pitch in and provide that necessary financial support to secure better management plans, pragmatic management plans to take care of wildlife conservation as well as forest rights. Today, we are living in an era where community welfare-centric conservation management is in thing. Symbiotic relationship between local forest dwellers and government is the key to resolve a conflict which statutes, FRA or Wildlife Protection Act did never intend. Next slide, please. Now, these are my concluding words that what is the solution to the whole issue? My personal experience has shown that at times wildlife being just to safeguard their turf, they are jealously protecting provisions. There is need to have an empathy. There's no need to compromise the principles of wildlife management. At the same time, empathy towards those forest dwellers is equally essential. At the same time, Gram Sabhas also have to be sensible. Some Gram Sabhas are proactive, they are positive. There are Gram Sabhas which are troublesome. So this is also a mandatory requirement. Role of NGOs becomes very crucial to really bridge the trust deficit wherever it exists between the local tribals and the wildlife wing of forest department. Wherever these NGOs have come forward, they have effectively bridged this trust deficit bridge. And wherever, because Vivekanand Girijan Kalyan Kendra in BRT Hills is one classic example where their active role has resolved the issue of conflict there in BRT Tiger Reserve. So such conservation model can provide a ecologically safe, socially stable, and economically viable solution. A point which always really haunts my mind: three T's, trees, tigers, and tribals, always coexisted symbiotically for centuries. Our acts came in in 20th century. Wildlife Protection Act came in 1972. Forest Rights Act came in 2006. Indian Forest Act is their rights is 1927. Even when these acts were not there, these three components coexisted. What went wrong during this intervening period is something which calls for deeper introspection by all the stakeholders, not only by wildlife wing or forest department, but society as a whole. Because if we see the statistics, it's very interesting. Forest area is 21.71%, of which 9% is open, 9% is moderately dense, and only 3% is dense forest area. And this 3% of dense forest area overlap with 3.76% 3.76% of wildlife areas, which incidentally overlap with scheduled areas, and the scheduled areas overlap with forest dwellers and tribals. And these islands, which which are repository of precious biodiversity, are the islands, while while economic development is going all around. So challenge before us, find out a model which sustains itself, where we safeguard the interest of local tribals, we also safeguard the interest of wildlife. At the same time, we don't compromise on economic front. Such sustainable models are possible, they are viable, and they are stable. Challenge before us to find them, so that such misconceived notions that forest rights and wildlife management provisions, wildlife protection purposes are at loggerheads is resolved and a better harmony is arrived at. Thank you so much. With these words, I conclude my presentation. If there are any questions, I would be more than happy to answer them. Thank you.
Thank
So if I'm
you.
there,
Yeah, thank you, sir. I would I would request Lovish to take over and moderate the session, moderate the question answers if there are any. And we have a good participation today. And thank you, sir. Thank you very much for enlightening us with the in-depth knowledge of understanding FRA. Over to you, Lovish.
Yeah, thank you, Jose. So I have a question. I have already wrote that on the chat box. If you can see, sir. So the question is that is it more pragmatic approach if the dwellers seek their community right rather than seeking enforceability of their individual rights in order to further the object of this FRA 2006? Like, which is more better for them?
If you see, I was just looking at the figures. So community forest rights cases which have been settled, they are to the tune of about 28,000 cases, okay? And individual forest rights cases are about 2,66,901. CFR and IFR, both are important. For an individual tribal, right to till, to plow his land, which has been plowing for last over so many years, becomes his primary concern. And logically also, because those people who have been plowing a particular land for hundreds of years, they need to be given that right, especially right to till, right to hold, right to be there. At the same time, community forest rights are equally important because they take care of their general livelihood requirements. Both are important. One cannot substitute the other, ironically. Okay. Therefore, community forest rights will take care of their livelihood requirement, while individual forest rights will take care of their individual rights for as cultivation, for their home, for their local requirements, cattle, and other things. Both are important, and one cannot really substitute the other one. You are not audible, Lavish. Will you just switch on the mic? Yeah.
Thank you so much, sir, for elaborating on the question. And I think there are other questions from the participants.
Yeah, in fact, I'm not able to see the chat box. If somebody may just read out the question, that would
I'll
be
read for you.
helpful.
I'll read for you. So we have Aishwarya Menon, and she's asking, hello, sir, in places like Sanjay Gandhi National Park, encroachment is an issue. How can you satisfy the local community, the encroachers from the cities, and yet manage the well-being of the national park and the biodiversity?
Well, Aishwarya, as of now, we discussed scheduled areas, tribals, and forest dwellers' interests. FRA does not cover the encroachers, does not give any protection to the encroachers of the areas on the fringes of SGNP. Because neither they are, I think, those who are encroaching upon, neither they are forest dwellers nor they are tribals. They are builders. And those people who are encroaching those lands, litigation for them is the best answer. And I think local officials there are taking appropriate measures to ensure that encroachment doesn't happen there. I hope I answered your question.
Yes, I guess, Aishwarya, if you have anything more to seek clarification upon, just feel free. You can unmute yourself. Else, I'll move forward to the next question. Please unmute Miss Menon.
Yeah, hello. Hello, am I audible?
Yes, ma'am, you are very much.
Yeah. So actually, like I understand that encroaches are not allowed, but would allow or having some kind of law inside, like for the forest, from the forest division itself, help, because I feel like the encroachers, even though the litigation can be done by government, a lot of times the need of inclusion from the forest department is also required, because in Sanjay Gandhi the encroachers also include one tribal group as far as I'm aware. So that is why I was
In fact, let me just tell you, scheduled areas have been notified by the respective governments. And to the best of my knowledge, SGNP area, how much of that area is falling in scheduled areas? Only to that extent FRA will be applicable. Outside scheduled area, this FRA may not be applicable. And for those encroachers who are falling outside the notified area, they may not enjoy any immunity in regard to the provisions of FRA. For them, simple provisions of IFA will be attracted. Let me just clarify. FRAs is squarely intended to those tribals and forest dwellers who are occupying notified scheduled areas, and that too if they have been in occupation for last over 75 years, 3 decades. An encroacher who is encroaching right now on any area of SGNP may have been staying there for last over 3 decades. Therefore, the provisions themselves prohibit them from enjoying such privilege.
We'll move to the next question. The question is from Mr. Raman K, and I'll read for you. So he says, what is happening after settlement of the CFR and IFR? Are the government steep in any state to facilitate proper agricultural practices and management planning for CFR?
Yeah, in fact, Raman is a good friend of mine. He is a retired forest officer from Madhya Pradesh, a very experienced forest officer himself. So thanks, Raman, for asking a very thought-provoking question. Let me just tell you, at least in Maharashtra, in areas of Dhule and Nandurbar, where there are a lot of tribal areas, a special these horticultural plantations have been encouraged, and those tribals really have undertaken those mango plantation and kaju plantation on their IFR areas. And especially this BIF, this NGO, they have also contributed constructively towards better livelihood security for these tribals. And one person, Mr. Chaitram Pawar, has done a wonderful job there through his NGO there in Nandurbar district. And especially in Gujarat, these BIF people have done a human service to uplift livelihood security, especially to on these IFR areas, on these individual forest, related areas, where actually these horticulture plantations supported by market has uplifted their economic livelihood substantially. So two examples are really there which come to my mind. As a matter of policy, till I was there in the service, no such policy decision had taken place.
So that is what hurts us, that we have taken a very challenging decision of converting these lands to individual forest rights, and we believe that they know how to do the cultivation, and they fall into a trap of high input, high insecticide, pesticide, fertilizer agriculture practices that is generally favorable in the agricultural land. They are also trying here. They are falling into a trap, and that is not a market support. I'm not talking about, this wonderful example you have given that really puts us in a lots of comfort zone. But what I am asking for, like you said, the policy. There doesn't exist any policy anywhere. In any state, I tried to find out from many states, no state talks about. When you are bringing about a major shift, so unless you have a policy and a government plan and a scheme in place, I think it is it is feeding to the populist demand of the political establishments rather than the bona fide requirements of the tribals. That is what our standing is.
In fact, your point is very well taken, and I only would hope that somewhere in future uh, a permanent policy solution to this issue also comes up. That's all I can say.
So even for the Gard Chiroli of your state, we see that we hear that is the perfect example of CFR. That is what is talked about, the best example of CFR management. But we keep on hearing different kinds of stories, and CFR per se, unless you have the management planning inbuilt, rather than leaving it to, some good wisdoms of the an officer or a good NGO stepping in. Rather than that, we should have a policy in place and a program to have proper landscape-based planning which takes into consideration all the requirements. Otherwise, it is simply, I feel the general perception is after the feeding the populist demand of the, I don't know, I'll not like to name anybody, people are forgetting them. That will have a long ranging negative impact on the biodiversity as a whole. That is our fear, unless we step in and do something. So that's why I was looking forward to this, listening to this webinar. Thanks a lot, sir.
Anyway, Raman, you are right. Law provides the mandate. Okay. Only thing is how to translate that mandate into workable ground reality. That is a challenge, That gap exists. And that is why I said, example of BRT Hills and Simlipal, I think there are two examples which are recorded. I personally know Dr. H. Sudarshan of VGK, Vivekanand Girjan Kalyan Kendra, who has done a wonderful job. So, well, problem is there, sprinkling. Islands of success are also there, but how to replicate those islands of success is the challenge. Agreed.
Okay, thank you, sir.
Thank
You can
you.
move to the next question. Thank you.
Yes, moving to the next question. So the question is asked by Ahana Banerjee. And the question is, while harmonious existence is possible, communities staying in the forest would only increase in size with time, which will eat away at forest lands and disturb the biodiversity. So wouldn't it be more prudent for the government to incentivize the tribal youth to move to the city?
Well, I think your question statistically and scientifically makes sense. Having said that, I spent about 12 years in areas of Melghat and Bhamragarh district. They are tribal, dense, populous areas of one of Amravati district, one of Gadchiroli district. Due to reasons, natural reasons, population of these areas for at least last 3 decades have not crossed that threshold limit of the carrying capacity of that particular habitat. The day, I think, the day these forest managers or local officials find that population growth is high enough to cross the carrying capacity of the natural area where they are inhabiting, there your question certainly would become relevant. But having said that, there is always tendency that young youth of these tribal families, they already have started moving towards city, so even if we don't do anything, that migration is already there. But those traditional families of tribals and forest dwellers, usually due to n number of factors, their population density so far has not risen to those alarming concerns.
Thank you, sir. I got my answer.
Thank you.
So moving to the last question. The question is asked by Tanushree Srivastava. She's a good friend of mine, and she's currently working as the manager and project head of the Western Himalayan Mountain On-Grid project of WTI. The question asked is that in protected areas in Jammu and Kashmir, bona fide herders have started leasing out their lands to other non-bona fide herders, which is increasing tremendous pressure on the forests and wildlife. So what implications do you think settling FRA rights in such areas would have on the wildlife in such areas?
Well, I think after promulgation of Article 370, a lot of changes have taken place in Jammu Kashmir, As of now, I confined my presentation to the legal provisions. Existing legal provisions have the inherent resilience to accommodate the problems of the ground situation. Having said that, ground reality of every state for that matter, every tiger reserve in country is different. Now you have mentioned about Jammu and Kashmir, Jammu Kashmir issue. I really am not privy to. I mean, I don't have information about the level of issues or level of problems they are facing in terms of accommodating the rights of tribals there. But scheduled tribe of Jammu Kashmir, they form substantial population. That is true. I checked from the literature also, and that is going to be issue of concern. But as of now, I may not be in position, just due to the dearth of information, to comment upon a possible solution to that problem.
Hi, sir. I just wanted to make a comment on this. I was just wondering, like in general, because these people think that kind of an ownership to the such land areas, right? Even if they are in the protected areas, because these permissions are given from the forest department, and especially in these high altitude areas, there is a different forest department and there is a different wildlife department. So these permissions technically come from the forest department, and this is long before these areas were not notified as protected areas. So I don't know. That's why I thought I will ask you that what do you think provisions should be made in such areas?
In fact, I have not been able to uh, get the question correctly, because wildlife wing is a part of overall forest department. Okay,
Yeah, I agree, but
any order issued by forest department
right.
is practically a collective decision of all the wings put together. There may not be a decision of forest department where wildlife wing may have a disagreement by and large. So really, what's the question? I really could not get at that.
I just wanted to inform you that in these high altitude areas, there is, the wildlife and forest departments are actually separate. They are not the same departments. So the permissions from the forest from a different department, which is called the forest department, and the wildlife department is separate. So my major question was that, because these livestock herders already consider kind of an ownership to these places, and that's why they have started renting out these places to other people who don't have these rights. So in such cases, if you think we settle these FRA rights and we give these rights to them, that okay, you have a proper legal right to use these areas. How
I think
there is actually this practical issue in J&K, which I understand. So what happened there is, even after the abrogation of 370, I had the occasion of visiting J&K for the wildlife crime prevention training. What happened there is, they have a separate forest department and a wildlife department. So if in case any offense is committed under Wildlife Protection Act, and it's before a forest officer, like a officer belonging to the forest department, which is a separate department, and wildlife department is a different department. So there are situations where an offense is, comes to the knowledge of a forest officer. He would actually not take cognizance of an offense under the Wildlife Protection Act. They will wait for the wildlife department to come and take cognizance of such offense. There is this issue. I think it was prior to this 370. They had working separately. There were these two wings working under the main forest department, but then they call it forest department as a different department and wildlife department being a separate entity. So there is this practical issue, and I think they have not merged it to come up with a one forest department only.
Well, in fact, Lavish, I really, I do not have any intimate knowledge of for Jammu Kashmir Forest Administration, but just to give you a legal solution to the problem, no, every inch of national park or wildlife sanctuary essentially had been a reserve forest area. Okay, that area being a reserve forest area certainly already had attracted all the provisions of Indian Forest Act, right since 1947. Wildlife Protection Act are provisions which are acted over and above them. Okay. Forest official, as per the act, is also deputy chief wildlife warden. You know, therefore, he just legally has no right to say that he cannot handle a wildlife case because lawfully he is notified as deputy chief wildlife warden. Okay. And henceforth, why this problem is emerging there, I am at loss to understand. At least in Maharashtra, we did not have any problem because as a DFO, even I handled wildlife cases when I was DCF in Sindhudurg. In Chaparala, I handled wildlife cases. Therefore, it is the question of who is who is in administrative control of that territorial unit. Whosoever is in administrative control of the territorial unit is legally entrusted to take the legal provisions against any errant. That is the position of law. And it's very clear, very crisp clear. Therefore, there should not be any problem. I hope, Lavish, I have answered your question. I don't.
Yeah, rightly said, sir. I guess,
In fact, I am seeing Mr. Sachin Tripathi ji. He is a professor at National Law University of Nagpur. If he's there, I mean, certainly I think his comments would be very valuable. He's also one of the very experienced professor in the field of law. Tripathi ji, are you there? Anyhow, Lavish, you can go ahead.
Tanushri is back. Tanushri, if you want to repeat your question.
Yeah, hi sir. Yeah, I just got disconnected. So I just wanted to know your views on this, idea of settling these rights where the pressure on the forest and wildlife is already so much. So what do you think, how good it would be in such areas?
Tanushri, if I have understood your question correctly, there is no provision of subletting a right which a tribal has got. Okay.
Of course, yes.
And therefore, any subletting by any allottee of a land becomes unlawful to that extent. Okay.
Yeah.
And if he or she is doing, that is a clear breach of law, and law will not extend any protection to him or her. As simple as that.
Yeah. Yeah. I agree. Great. Thanks a lot, sir.
Thank you.
Yeah.
Thank you, sir. And that was the last question. We have no more questions left. So thank you so much for your time and this insightful question. We look forward to have such more webinars in the near future where we can talk about more policy matters concerning the conservation cause. Thank you again for your time. And I look forward to have such more sessions with you maybe in the coming months. So thank you again for your time.